Well, what's up, investors? Hey, I want to talk really quickly about something that has been generating a lot of buzz in the property management and landlord community over the last few days. If you haven't heard, on May 22nd, 2026, the Department of Housing and Urban Development, HUD, issued an enforcement guidance memo that has genuinely changed the landscape around emotional support animals in rental housing. And I want to break this down for you so it's a little more clear, because there's a lot of misinformation already circulating. And the last thing any of us need to do is make a policy decision based on incomplete information. So let's start at the beginning. And where's that at? Well, let's first go over what is an emotional support animal and how is it different from a service animal. There's a very clear distinction that trips up a lot of landlords, and honestly, it trips up a lot of tenants too. So let's get clear on it. A service animal under the Americans with Disabilities Act is an animal that has been individually trained to perform a specific task for a person with a disability. We're talking about a dog trained to guide someone who is blind, a dog that can alert someone who is deaf, an animal that can detect an oncoming seizure, or a psychiatric service dog that performs specific trained behaviors to interrupt a panic attack. The key word here is trained. The animal is doing a job. It has learned a specific skill to assist with a specific disability. An emotional support animal is different. An ESA does not need specialized training. It provides comfort, companionship, and therapeutic benefit simply through its presence. A dog that helps someone manage anxiety by being there. A cat that helps someone with depression get out of bed in the morning. These animals provide very real benefits to people with very real disabilities, but they are not trained to perform a specific task the way a service animal is. Under the old framework, both types of animals were protected in housing. A landlord generally could not charge pet fees or deny housing to someone with either a service animal or properly documented ESA. That has now changed at the federal level, and here is exactly what happened on May 22nd. HUD issued what is called an Enforcement Guidance Memo. This was signed by FHEO Assistant Secretary Craig Trainer, and it took effect immediately. And it did a very few significant things. First, it permanently canceled HUD's prior guidance documents on ESA. HUD had issued guidance documents in 2013 and again in 2020 that told landlords they had to treat ESAs as assistance animals, not pets, and they could not generally charge pet fees or deny housing based on an ESA. Those two guidance documents are now gone. Second, HUD replaced an old ESA standard with an ADA service animal standard. That means going forward, HUD will only recognize animals that have been individually trained to perform a disability-related task. An animal that simply provides comfort, though through its presence, no longer qualifies for federal enforcement protection under HUD's new framework. Third, HUD instructed its staff to stop pursuing complaints from tenants whose ESAs have not been individually trained. Any open cases that were under investigation have been put on hold and sent for a review under this new standard. In practical terms, those cases are almost certainly going to be closed without finding a violation. And fourth, HUD signaled that it intends to go through a formal rulemaking process to update its assistance animal regulations. But here's the critical part. They gave no timeline per the usual. That process, called notice and comment rulemaking, takes time and is subject to legal challenge. Until it is complete, the underlying Fair Housing Act regulations, which have actually not changed. So, what did not change? I want to spend some real time here because this is where I see a lot of landlords getting excited and potentially getting themselves into some serious trouble. The Fair Housing Act itself has not changed. Congress didn't act. No court has ruled that ESAs are excluded from housing protections. HUD has simply decided to stop enforcing that law for tenants with untrained ESAs. That's a very different thing. Your right to sue in court as a tenant is still fully intact. Tenants have 2 years from any discriminatory act to file a lawsuit in federal or state court. HUD's enforcement memo says so explicitly. So landlords who immediately start charging pet fees for ESAs because they think the coast is clear are potentially walking into private suits. And then there is Section 504 of the Rehabilitation Act, which covers housing providers that receive federal financial assistance. The HUD memo explicitly does apply to Section 504 complaints. If you operate public housing or HUD-assisted housing, you need to be specifically careful here because you may have stronger obligations than ever under Section 504. And of course, fair housing organizations can still investigate and sue on their own behalf under Fair Housing Act and private HUD action. HUD is pulling back from enforcement, and it does not eliminate those organizations' ability to act. So what does this mean if you're a landlord in California? All right, now this is the section that is most relevant to all of us here in California. And frankly, it's the most important thing I'm going to say in this entire video. California has its own fair housing laws called the Fair Employment and Housing Act, or FEHA. And California's FEHA independently requires housing providers to make reasonable accommodation for disabled people. Critically, California's protection for people with assistance animals are conditioned on whether the animal is trained. Untrained ESAs still fully protected under FEHA. The agency that enforces FEHA is California's Civil Rights Department, the CRD. It operates completely independently of HUD. The HUD memo has absolutely zero effect how the CRD operates. So what does that mean practically? It means that if you are a California landlord and you start charging pet fees for ESAs, tenants based on this HUD memo, you are still exposed to a complaint with the CRD under a lawsuit with FEHA and potentially liable under the Unruh Civil Rights Act, which carries statutory damages per violation. I want to be direct about this. The legal risk for California landlords around ESA has not meaningfully decreased. What changed is federal enforcement. What did not change is the state enforcement here in California. State law is sat on the floor, not the federal level. So state level, not federal. So the bigger picture, and this is why it's going to keep evolving. Here's something I genuinely want to share with you as honestly as I can. This is not the end of the conversation. This is the beginning of a new chapter in a long-running legal debate. HUD has said it has planned to do formal rulemaking. That process will involve a public comment period, and you can expect disability rights organizations, fair housing advocates, tenant groups, and legal scholars to weigh in aggressively. It is going to be contested, honestly. There will almost be certain legal challenges to whatever rule HUD eventually proposes. Courts will weigh in, state legislatures may respond, Congress may respond. The ESA landscape has been evolving for years, and this memo, as significant as it is one in an ongoing story. I fully expect we'll see changes, clarifications, court, and new guidance multiple times in the upcoming years, possibly many, many times. That means for you as a landlord or property manager is staying informed is no longer optional. You need someone in your corner who's watching this stuff closely, reading the memos, tracking the court cases, and translating all of it into plain language before it becomes a problem for you. Now, what is Wellspring Property Management going to do here? So Wellspring Property Management is not going to make any policy changes right now, not one. That is a deliberate decision, and here's the thinking behind it. We do not have formal HUD guidance yet. We do not have clarity on how California's CRD is going to respond, and we don't know how California courts are going to treat the cases that we already have in progress. And we do not believe that the right move when you're operating in a legal environment such as California is to rush and start making changes that could expose our property owners to liability. We're going to wait. We're going to watch. We're going to consult with legal counsel. And when we have enough information to act with confidence, we will communicate those actions clearly with every property owner we work with. Our promise to you is simple. We will not let you get caught off guard. Every time something meaningful changes in this area, you will hear from us before you have to ask. What you should do right now, if you're a landlord in California watching this, or if you manage your own properties here, is my practical advice. Do not change any ESA policies yet. The legal risk in California has not gone away, and moving too fast could cost you significantly more than the pet fees you are thinking you're going to recover from this policy change. If a tenant presents an ESA request, handle it the way you always have. Document everything, consult with your attorney, and make reasonable accommodation decisions carefully. Make sure your ESA documentation process is solid. Under both old and new frameworks, you are allowed to request documentation from a licensed healthcare provider to confirm that the tenant has a disability-related need for the animal. Now, make sure that documentation is from a legitimate doctor, legitimate treating provider, not a boilerplate letter purchased online, because those are going to carry even less weight now under the federal standard. And finally, stay connected to professionals you trust, whether that is your property management company like Wellspring Property Management, your real estate attorney, or a fair housing organization that can help you understand all of your obligations. This is not a moment to be navigating alone. So in closing, I know that was a lot of information, and I appreciate you sticking with me through it. This is Chrissy with Wellspring Property Management. As this circumstance continues to evolve, we'll stay abreast of going to evolve and let you know. So the bottom line is this: a significant shift has happened at the federal level on May 22nd. In California, the practical impact for most landlords is limited right now because the state law still provides strong protections for ESA tenants. HUD will be doing more rulemaking, courts will weigh in, and this is going to keep developing. At Wellspring, we're going to watch everything so you don't have to. If you have questions about your specific situation, reach out to us directly. And if you found this information helpful, please share with a fellow property owner who could use the information. Once again, you can find us at wellspringpm.com. We service Stockton and Ridgecrest and lots of places in between. Have a great one.